Breaking news tonight, federal judge Tanya Chutkin has taken an extraordinary and historic step involving Donald Trump. Less than 6 hours ago, she issued a formal criminal referral to the United States House of Representatives, marking the first time in American history that a sitting federal judge has directly initiated impeachment proceedings against a former president who is already under active criminal prosecution. Judge Chutkin confirmed multiple violations of court orders, repeated witness intimidation, and ongoing obstruction of justice. January 10th, 2026 now stands as a moment constitutional scholars say could permanently reshape the boundary between judicial authority and claims of executive immunity. A federal judge has formally referred criminal conduct to Congress for immediate action. Take a look. The 47-page referral document filed at exactly 3:17 p.m. Eastern Time leaves no room for interpretation. Quote, "The defendant's repeated violations constitute a clear and present danger to the administration of justice and demand immediate congressional intervention. Remember when I warned that Trump's courtroom conduct would eventually force the judiciary to act? Remember when I said judges would not tolerate obstruction indefinitely? That wasn't exaggeration. It wasn't theatrics. Because less than 7 months after his conviction in the classified documents case, the machinery of accountability is now moving decisively against him. Let that settle in. A federal judge has effectively handed Congress a detailed impeachment roadmap, while Trump is simultaneously appealing felony convictions. This is not rumor. This is not anonymous sourcing. This is unfolding in real time, documented in federal court filings available to the public. The National Guard has been deployed in Washington, D.C. Protests are forming outside the Capitol. Republican lawmakers from swing districts are breaking ranks as this develops. And Trump himself is flooding Truth Social with frantic all-caps posts about military tribunals, deep state coups, and urging supporters to defend the republic. I wish I were exaggerating, I truly do, but this is the reality we're in. January 10th, 2026, the day a federal judge concluded that a former president's conduct had become so dangerous that Congress could no longer delay action. Before we go further, let's be clear about something. You cannot rely on cable news to give you the full scope of what's happening right now. They worry about access, optics, and appearing neutral. That's exactly why this channel exists, to provide unfiltered analysis grounded in primary sources and actual court records. If you want to stay ahead of the story as it unfolds, subscribe to our free newsletter, The Breakdown. You'll receive detailed legal analysis, direct document links, and expert insight delivered to your inbox every morning before the cable panels even go on air. The link is in the description. And if you want to support independent reporting that tracks power, accountability, and the rule of law, consider joining our membership community. Members receive early video access, exclusive deep dives, and join a community that refuses to look away when democracy is under pressure. Now back to what just occurred. At 3:17 p.m. Eastern Time, after Trump violated his gag order for the 14th time in just 3 months, Judge Chutkin did not issue another routine contempt citation. She escalated dramatically. She sent a formal criminal referral directly to the House Judiciary Committee. And the language she used is unmistakably severe. Judge Chutkin wrote that Trump's conduct reflects a systematic pattern of obstruction, witness intimidation, and outright defiance of judicial authority, behavior that threatens the foundational principle that no individual is above the law. That phrase matters. Systematic pattern is not rhetorical language. It's a legal conclusion. It signals that this is not about a single lapse in judgment or one reckless post. It is documented, repeated, and intentional criminal behavior. And she didn't forward a summary. She sent the entire evidentiary record. 14 documented gag order violations with timestamps and archived screenshots. Transcripts from 7 contempt hearings where Trump was explicitly warned. Evidence of direct outreach to witnesses in active criminal cases, phone records showing coordination with co-defendants despite court-ordered no-contact restrictions, social media posts targeting prosecutors, judges, and potential jurors, internal communications from Trump's own legal team acknowledging the violations, and sworn expert declarations from former federal judges describing the conduct as unprecedented in modern American history. And then came the most damaging evidence of all, recorded conversations in which Trump is heard discussing plans to defy court orders with close advisors, evidence that directly establishes intent. That alone changes everything. This has never happened before. Not during Watergate, not during the Clinton impeachment, not during Nixon's Saturday Night Massacre. A sitting federal judge has never taken this step, ever. And Congress was not caught off guard. Articles of impeachment had already been drafted and quietly sitting in committee since November 2025. Those articles lay out 8 specific charges: obstruction of justice, witness tampering, contempt of court, violation of judicial orders, abuse of power, conduct unbecoming a public official, threat to the constitutional order, and incitement. Until Judge Chutkin's referral arrived, those articles had approximately 87 co-sponsors, all Democrats. That number didn't just increase, it exploded. As of this morning, the articles now carry 231 co-sponsors, a clear majority of the House of Representatives, enough votes to impeach immediately. And the names being added are not who anyone expected. Representative Mike Lawler of New York, Representative Don Bacon of Nebraska. Moderate Republicans who had defended Trump through 2 previous impeachments have now broken ranks. Congressman Lawler held a press conference this morning and said, quote, "I swore an oath to the Constitution, not to any individual. When a federal judge says a former president is obstructing justice, I have a duty to take that seriously." That statement came from a Republican representing a district President Biden carried about a Republican former president. The political ground has shifted. Democratic leadership has now invoked Rule 99, Section 2, a fast-track procedure that mandates a full House vote within 72 hours. That motion was formally filed this morning, which means that by Monday, January 13th at the latest, the House of Representatives will vote on whether to impeach Donald Trump for the 3rd time. 72 hours. That is the window Trump is facing. With 231 co-sponsors already committed, the arithmetic is unforgiving. Impeachment is now all but inevitable. The only remaining question is whether the margin is razor thin or whether it becomes a landslide as more Republicans defect over the weekend, and that list is growing by the hour. Moderate Republicans who were waiting for cover are now abandoning ship. They see a federal judge's criminal referral. They see documented evidence of obstruction. They hear voters worn down by constant chaos. And they understand they cannot go on national television defending obstruction of justice, not after a respected judge has signed her name to a 47-page referral. Trump's reaction has followed a familiar pattern. Since yesterday afternoon, he has been posting incessantly on Truth Social, all caps tirades about rigged courts, attacks on so-called Obama judges, claims of political persecution and conspiracies. But then came one post, one message that immediately set off alarm bells across Washington. If Congress moves forward with this witch hunt, patriots must converge on Washington. The Second Amendment exists for moments like this. A former president openly calling for armed resistance to Congress is not mere rhetoric. It is sedition. Every post he makes now becomes evidence. Every threat strengthens the case against him. He cannot stop himself. He is self-destructing in real time. Washington, D.C. is on lockdown. National Guard units are deployed across the Capitol complex. Steel barricades are rising around federal buildings. Pro-Trump demonstrators are gathering near the National Mall, while counter-protesters demanding accountability are assembling near the Supreme Court. Law enforcement is everywhere, preparing for Monday's vote. This is day 1. 3 days remain until the impeachment vote. 3 more days of chaos, 3 more days for Trump to incriminate himself further. 3 more days for more Republicans to break ranks. Everything we've been tracking for months, the contempt citations, gag order violations, witness intimidation allegations, appeals court rulings, Republican defections, has converged into this single moment. Impeachment is coming, and there is nothing Trump can do to stop it. What happens next is not speculation, it's procedure, and it is moving fast. The House vote will occur by Monday, January 13th, 72 hours from now, because Rule 99 has already been invoked. That fast-track rule exists for exactly these moments when leadership determines that delay itself is dangerous. With 231 co-sponsors already on record, impeachment is no longer a question of if, only of margin. Will it be narrow, 218 to 217, or will it become a landslide if 10 or 15 more Republicans jump ship over the weekend? Either way, Trump is about to become the first president in American history to be impeached 3 times. And this time, the charges are far more serious. They're not about Ukraine phone calls or January 6th rhetoric. They're about active, ongoing criminal obstruction, 14 documented violations, witness tampering, contempt of court, defiance of judicial authority, threats against prosecutors, coordination with co-defendants under court-ordered no-contact rules, and incitement to violence. These are not disputes over policy or political norms. These are direct attacks on the rule of law and the independence of the judiciary. That distinction matters because it will shape how Republican senators and the American public view what comes next. Once the House impeaches, the process moves to the Senate. A trial becomes mandatory. Chief Justice John Roberts will preside. House impeachment managers will present evidence drawn directly from Judge Chutkin's 47-page referral. Trump's legal team, if anyone is willing to represent him after his last 3 attorneys withdrew in November, will mount a defense. Then 100 senators will vote. Conviction requires 67 votes. Every Democrat plus 18 Republicans. That may seem like a high bar, but signs are already emerging. Senate Republicans who have long stood with Trump are hedging. Senators from swing states, Pennsylvania, Wisconsin, Arizona, are seeing the footage and imagining the political fallout. Senate Minority Leader Mitch McConnell is furious over Trump's Truth Social post calling for armed resistance, a post that directly endangered members of his caucus. Even if Trump avoids a Senate conviction numerically, he will be politically crippled. An impeached former president facing overwhelming evidence from a federal judge is a president without leverage, without credibility, and without a viable path back to power. And then there is Trump himself, the most unstable variable in this entire equation. His response so far has been erratic, threatening, and increasingly untethered from reality. Posts invoking the Second Amendment and calling on patriots to converge on Washington are not campaign theatrics. They are warning signs. Law enforcement is treating them that way. That is why the National Guard has been mobilized. That is why FBI field offices are actively monitoring far-right militia channels. Authorities are preparing for the possibility of another January 6th style event. This time sparked not by election denial, but by impeachment. They have learned not to dismiss Trump's words as empty provocation. January 6th began with a single line, "Be there, will be wild." The next 72 hours represent the most dangerous window. Trump knows impeachment is unavoidable. He knows his control is slipping. And history shows that when Trump feels cornered, he escalates, he lashes out, he destroys alliances, he invites disorder. That pattern is well documented, which is why officials in Washington are not sleeping tonight. At the same time, a criminal track is accelerating alongside the political one. Judge Chutkin's referral does not end with Congress. Evidence of witness tampering, obstruction of justice, and criminal contempt has also been forwarded to the Department of Justice. If investigators establish that Trump directly coordinated with witnesses to influence or alter testimony that constitutes subornation of perjury, a serious federal offense, witness tampering carries prison exposure. Obstruction of justice does as well. Multiple federal grand juries are already active in Washington, D.C., Miami, and Atlanta. It is entirely plausible that new criminal indictments arrive while Senate impeachment proceedings are still underway. We are now in constitutional territory that the framers anticipated but hoped would never be tested. Multiple accountability mechanisms operating simultaneously, impeachment in the House, trial in the Senate, and federal criminal prosecution. And hanging over all of it is a discussion no one wanted to have but can no longer avoid. Reports indicate quiet conversations about the 25th Amendment, discussions involving cabinet officials and Vice President Vance centered on capacity and fitness. The 25th Amendment allows removal without impeachment if a president is deemed unable to discharge the duties of office. It can move quickly, overnight if necessary. Trump could challenge it, but the decision would rest with the cabinet. And with impeachment already underway, the outcome would be clear. The mere fact that this option is being discussed tells you how severe the situation has become. Meanwhile, the Republican Party is fracturing in real time. Loyalists like Representatives Marjorie Taylor Greene and Matt Gaetz are doubling down, calling for protests and defending Trump without reservation. Pragmatists like Representatives Don Bacon and Mike Lawler are breaking away, citing their oath to the Constitution. Internal threats are escalating. Lawmakers who defected are facing harassment from Trump's base. And the party itself is tearing apart under the weight of Trump's collapse. With the 2026 midterms just 10 months away, many Republicans see electoral catastrophe ahead if they remain tied to this level of chaos. Internationally, allies are alarmed. A former American president threatening armed resistance while facing impeachment is not a normal headline. Adversaries such as Russia and China are watching closely, assessing instability, probing weakness. Domestic turmoil always carries global consequences, and right now, the United States appears unstable. So here is where things stand. 72 hours until a House impeachment vote. A federal judge has formally concluded that Trump engaged in obstruction and witness intimidation. A majority of the House has already signed on to the articles. The National Guard is deployed. Federal criminal investigations are accelerating. The 25th Amendment is being discussed. The Republican Party is splintering. And Trump continues to escalate rhetoric that only deepens his legal exposure. This is not noise. This is not hype. This is convergence. Everything that has been building for months, contempt citations, gag order violations, criminal convictions, appeals, judicial losses, is colliding into a single compressed moment. What happens in the next 72 hours will shape the future of presidential accountability, judicial independence, and the rule of law itself. And beyond the mechanics of impeachment votes and Senate trials, a deeper reckoning is now underway, one that cannot be delayed or undone once set in motion. What Judge Chutkin did shattered a long-standing assumption in American politics that federal judges would never directly intervene in the congressional impeachment process. That barrier is gone. The judiciary has now stepped forward and declared that this conduct is so severe that Congress must act immediately. That shift alters the balance of power in a way the country has never experienced before. For decades, presidents survived by running out the clock. Delay investigations, appeal rulings, wait for elections, let statutes of limitations expire. But that strategy is gone for Trump. Judge Chutkin's referral collapsed timelines. It forced Congress to act on a judicial clock, not a political one. And once that clock starts, it doesn't pause for polling numbers, fundraising, or campaign rallies. That's why Trump's allies are panicking behind the scenes. Even if they act loud publicly, they understand this is no longer about impeachment alone. It's the start of exposure. Senate trials bring subpoenas, sworn testimony, document production. Every layer peeled back creates new legal risk, not just for Trump, but for anyone who enabled him. Staffers who delivered messages to witnesses, donors who funded legal defenses designed to delay justice, operatives who coordinated social media attacks on judges, lawyers who filed frivolous motions in violation of ethics rules, advisors who counseled contempt. People who once believed loyalty would protect them are now realizing it only ties them closer to the blast radius. Cooperation becomes rational, silence becomes dangerous. And once that shift starts, it accelerates. Trump senses it. That's why his rhetoric has turned openly authoritarian. He isn't posting to persuade voters anymore. He's posting to intimidate institutions. Calling for armed patriots to converge on Washington isn't political messaging. It's a threat meant to freeze House members, make senators hesitate, and make prosecutors fear consequences for doing their jobs. But it has backfired spectacularly. Threats don't stop institutions when they're public and documented. They harden them. Every post is archived, time-stamped, and potentially admissible. Every escalation reinforces the case that Trump is not just defiant, but dangerous. That's also why security in Washington looks the way it does. Officials aren't preparing just for protests. They are preparing for the possibility that Trump's words trigger real-world violence. The memory of January 6th isn't theoretical. It's operational. Agencies know exactly what happens when rhetoric turns to action, and they are determined not to be caught off guard again. Meanwhile, Trump's political narrative is collapsing. He can no longer credibly claim a witch hunt when a federal judge bound by law and ethics initiates impeachment. This wasn't a partisan cable host. It wasn't an opposition research firm. It was Judge Tanya Chutkin, a lifetime appointed federal judge acting on documented criminal conduct. That distinction matters enormously to voters who may be fatigued by chaos, but still care about legitimacy. And here's the quiet truth many won't say aloud yet. Even if Trump survives Senate conviction, his political future will not recover. Authority once broken doesn't reassemble. Every executive order would be challenged, every policy decision scrutinized, every appointment viewed through a lens of instability. Governance becomes nearly impossible. That's why contingency planning is happening across the Republican National Committee, in campaign offices and among major donors, covering scenarios from conviction to resignation, a fractured 2028 primary, or the possibility that Trump becomes the first major party nominee running while impeached 3 times. This is what constitutional crisis management looks like when the guardrails are under stress. So when people ask if this is the end, the answer is more precise than yes or no. It is the end of the illusion that presidential defiance has no consequences, the illusion that courts cannot enforce their own orders, the illusion that obstruction of justice is just political hardball. What remains now is process, cold, methodical, relentless. And process is the one thing Trump has never been able to dominate. The countdown is real, the record is locked, and the next move belongs not to Trump, but to the United States Congress. What happens in the next 72 hours will not just determine Trump's fate. It will determine whether the rule of law still holds weight in America. Once impeachment moves from theory to action, everything changes. The stakes harden, the language sharpens, the consequences become unavoidable. By the time the House gavels in for Monday's vote, there will be no room left for ambiguity. Members will not be voting on personality, partisanship, or political calculation. They will be voting on a documented record compiled by a federal judge, reinforced with court transcripts, gag order violations, and witness testimony. That matters because it removes the usual defenses. There is no plausible deniability left. No, I didn't know. No, it was taken out of context. The paper trail is complete. That is why the atmosphere in Congress feels less like debate and more like preparation. Offices are coordinating security. Leadership teams are planning multiple outcomes. Legal counsel is on standby. Everyone understands this is not just another impeachment vote. It is a constitutional rupture point. Trump understands it too, even if he cannot admit it. His behavior reflects a man who knows time is no longer his ally. That's why the rhetoric has escalated from witch hunt to military tribunals. That's why he isn't trying to win arguments anymore. He is attempting to intimidate witnesses and threaten institutions. He's betting that fear will slow the process, that chaos will make Congress hesitate, that violence will buy him time. But fear works differently when it is documented. When threats are recorded, archived, and entered as evidence, they lose the power to intimidate and gain power to convict. Every post Trump makes now is not a defense. It is an exhibit. This is also why the 25th Amendment remains part of the conversation. It exists as a pressure release valve for exactly these moments when a former president's actions raise serious questions about fitness and stability. It is faster than a Senate conviction, more immediate. The fact that it is being discussed shows just how seriously officials are taking Trump's behavior. Meanwhile, the criminal investigation continues regardless of Congress. Federal prosecutors do not pause for political calendars. Grand juries do not stop reviewing evidence because a former president is angry. In fact, impeachment accelerates exposure by bringing more evidence into the open under oath. That convergence is what makes this moment so dangerous and so decisive. Trump is not facing one threat. He is facing several, all advancing at once. Congressional impeachment, Senate trial, federal criminal prosecution, and 25th Amendment discussions. None of these processes depend on his consent, and the Republican Party knows it. The fractures we are seeing now are not temporary. They are structural. Once members publicly defect, the dam does not reseal. It breaks. Every new defection makes the next one easier. Every silence speaks louder than a defense. That is why the next 72 hours will feel relentless. More evidence from Judge Chutkin's files, more statements from defecting Republicans, more resignations from Trump's legal team, more pressure from constituents, and more panic from a former president who has never been forced to confront a system that will not bend. Trump built his political identity on the idea that rules don't apply to him, that institutions can be bullied, that loyalty is more powerful than law. What is happening now is the collapse of that belief, not rhetorically, but procedurally. So when the House finally votes on Monday, it won't feel like a dramatic climax. It will feel inevitable, like the final step in a sequence already determined by evidence, procedure, and time. The question is no longer whether impeachment happens. The question is what survives afterward.